Welcome, welcome to one of our final sessions at IMX Virtual. Saved some of the best for last year with Lance Danino and Mark A. Bear, partners at Jones Walker. They are well known in the maritime world, both Jones Walker and individually Mark and Lance for all that they do. So today they're presenting on managing risk through MSAs and charter agreements. Mark and Lance, thank you very much. I'll tell you that I do know that they're willing to take questions. So anyone who has questions, please enter them in the Q&A on the right. Thanks a lot, guys. I'll leave you to it.
Thanks, Spence. We appreciate the opportunity to speak today, and always appreciate everything that you and your team at Waterways Journal does. So happy to be a part of IMX again, as both Lance and I have spoken in the past. Just in case everybody's wondering why we're not social distancing, we are COVID-free. Everybody's been checked. It's all good, and that's how we roll. We like to do as much as we can for the industry, getting out and providing as much educational opportunities as we can. And in this type of setting, we can have a lot of good crosstalk in doing so, because in our roles in representing the clients that we do, we all see things a little bit differently and come across different issues. So what we've put together today is a presentation to cover some of the issues that we've seen post-pandemic with our clients and others in the industry that relate to COVID-19 specifically, but not all the time. Because if you think about it, at the end of the day, it's all about compliance, managing risks, and training. And the key to all of it is knowing what you need to do. And so what we hope to do today is highlight some of the issues that we've seen post-pandemic in some of the contractual areas that hit us all, sometimes on a daily basis, but more so since the pandemic, since issues have been raised as we've seen changes in the industry and the operating environment. With that, I'm going to turn it over to Lance to kick off.
Sure. So sort of to follow on what Mark said, so we all know that, the inland marine industry has been deemed essential by the Department of Homeland Security. So operators have been, facing these ever evolving risks. And on our first slide here, we laid some of them out, just as sort of what we've seen from the client perspective. COVID-19 has obviously caused an increase in costs around the board. And we've also seen with some of the delays in compliance, some slippage in areas. And it's nothing, you could inadvertently walk into a non-compliant situation. So we have that as one of our sort of increased risks or liabilities that folks are facing post-pandemic. We've seen an increase in sort of contract terminations, due in a lot of respects to financial instability of contractual counterparties. And even customers. And then there's always, and I'm sure, you've seen a lot of content pushed out on force majeure and in light of the reduced demand for services. And we'll cover some of that really at a high level. And then obviously with all the introduction of the new technology, there's just a proliferation of advanced, technologies that are raising increased cybersecurity risks. And we've talked about those for a number of years. And now it seems to be really bringing it to the forefront with a lot of people. And it's, although not necessarily a requirement, I think we can all agree it's probably heading that way.
There's no question about it. In fact, can we go to the next slide?
Sure.
We can flip to the next slide. This really kind of sums up what we would like to talk about today. And we'll try and stay away from a lot of the legalese, even though we will get into some of the technical aspects of force majeure and sub-M in that regard. But at the end of the day, what COVID has done is really accelerated a lot of these issues for the industry, and not just the marine industry, but other sectors of the market as well. And as we've always said, education equals best practices equals protection. So there's no way to eliminate risk. There's no way to fully eliminate liability. We can do as much as we can in contractual matters in reducing risk and covering things under insurance and of course having the right indemnity obligations for the parties that contract together. But at the end of the day, what saves us and what saves you all is education, knowing your operating environment, understanding clearly what the do's and don'ts are, what the tasks are, implementing those best practices, and that ultimately leads to protection. So even though you have a contract and you think you've got everything nice and tight and tied up, it's not always so, because as we all know, working on the river, at the end of the day, what happens is if the people aren't implementing the programs, it doesn't matter what the contracts say, there's going to be some risk and liability. So that's really the big takeaway here.
Yeah, so you can go to the next slide. So absolutely to follow on what Mark just said, and I am actually involved currently in a case that I think brings a lot of what Mark is saying really into focus. And this is a case that's actively being litigated. It's been delayed quite a bit because of the pandemic. So I can give you a sense of what's going on. I can't answer the ultimate question because we don't really know where the court's going to go yet. But just to give you an idea of sort of what Mark's talking about. So in this instance, we had an owner of a towboat that was covered by Subchapter M who turned control over the towboat to an operator by contract. And it really doesn't matter the form of contract, but it was a contract, and it contained all of your usual requirements to comply with applicable law, defend, indemnify, and provide insurance. On the compliance with laws, the contract actually required the operator, and I've got the quote there on the slide, to adhere to a valid safety management system that's compliant with all applicable laws. No reference specifically to Subchapter M, but nonetheless compliant with applicable laws. So during the course of the operations involving this towboat, there's a significant crushing injury sustained by a deckhand. And then that deckhand brings claims against the owner and the operator. And then following the incident and sort of some of the post-incident investigation, it comes to light that despite what was in the contract, the operator didn't place the correct insurance, and also sort of was revealed to not have the financial wherewithal to cover the significant medical expenses and even a potential judgment for negligence. So about 2 or 3 months in, as we probably can all expect, the deckhand turns his attention to the owner, who is sitting there thinking, I'm completely good with my contract. I don't have to worry. Well, the plaintiff in the case has asserted a negligence claim against the owner that despite the contract, the owner is negligent in failing, and this is sort of not verbatim, but sort of a quote from an expert report, failing to verify and confirm that the operator adhered to a valid and suitable safety management system that was understood by the operator's crew. And that is an avenue of liability that I think fits really neatly in sort of what Mark's message was initially. And like I said, we are early on post-delay. I don't know where the court is necessarily going to go with it. I don't know what the scope or what the duty would actually look like, and what the scope of the duty might be. How far is a court going to ask an owner to dig into not only just the fact of a SMS, but implementation and follow through of an SMS.
And frankly, to follow up on that's what we're going to see in a lot of these cases relating to Subchapter M, and then managing your risk and liabilities not only through contracted insurance, but also following up, which is going to take us to our next slide, because what is crucial to a lot of vessel owners is the limitation of liability. And the way that Subchapter M is written, you have to do everything you can to manage that risk, because now you're not just following, say, AWO, RCP, or TMSA, depending on what type of operator you are, but you're having to comply with federal law that is now placed into regulation that requires these safety management systems, and you have to have certain components of those management systems. And the management of the company and the owner and operator of that vessel has to ensure that the crew are following those systems. So at some point, it could go from the bottom all the way back up to the top. And the fear is that the limitation of liability is busted. And that's a position you nor your insurer ever want to be in this new environment where we have sub-M and you have all these new issues related to COVID and everything else. So if you could flip to the next slide, I think that.
And one thing, before we go to the next slide, and I think you've actually seen this, but it is sort of also running into the regulatory side. I think we've had a client who's maybe involved in a larger, vessel-specific federal project, who's having to answer questions by the Coast Guard. Are you using Subchapter M compliant towboats in your operation? And that's caused folks just from sort of an operational side who may bring in horsepower or, need that on an as-needed basis to start having to look into these things. And do we have systems in place?
That's right.
Despite an executed master service agreement, we need to start looking into these things. And that I think is sort of, if you go to the next,
you have to have a system of
Right.
checks and balances, right? Right. So go ahead, Lance.
Yeah, no. So that brings us to I'm sorry, you go back a slide.
Yeah.
Yeah. We jumped one ahead on you. So yeah. So this here is sort of just our view of a good sort of list of documentation that, you would want to seek from your counterparty to verify compliance, and in doing so, hope to avoid some of these consequences that Mark has talked about, and at least show that you are exercising diligence in the course of working with this counterparty to ensure that they are compliant, thus avoiding negligence. So, and this is a pretty good list, comprehensive, both for, as we phase in fleets for purposes of Subchapter M, you'll see that there'll be, requirements to produce sort of your typical Coast Guard documentation or even RCP documentation if it's not available on the Sub M side. And we sort of have made this our go-to list for anyone looking to verify compliance of an outside vessel service provider.
And the important thing too is not only coming up with your list for vetting your subcontractors and or your customers, but also making sure that you have these requirements specifically listed and set out in your contract, so in your MSAs or your charter agreements, so that they can't say, well, I don't have to provide that to you, or it's privileged and it's confidential. Have it in an audit clause. And then that will help you grab a hold of that information. That will help you with your vetting process, so you can ensure that that party knows its liability and obligations to you in confirming that it also is operating under the same exact regulatory structure and compliance that you are.
And let me ask you this: what are your thoughts on, okay, if I'm an operator, or an owner vetting an operator, I make these requests and I get documentation.
Mm-hmm.
Does there need to be follow up? I mean, should you set up an internal system to sort of revisit these things? I mean, I think that's sort of a good practice as well. Is that, yeah, just doing it one time is great, but I think it needs to be part of a larger system internally to revisit these issues. Maybe it's annually, maybe it's
I think so.
every 3 years.
Ideally, you'd want annual audits, right, to make sure that there's continued compliance. You'd want a notification requirement that if they receive any deficiencies from the Coast Guard through their TPO, that you're notified as well. Any follow-up or supplemental audits conducted by the TPO, any 2692s that they may file based on groundings, whatever else, so that you're actually kept in the loop with respect to the company's operations and compliance overall.
Yeah, and I think if you go to the next slide, we've actually provided. Obviously the question is, what advice on what should the contract say to cover the issues? And I guess to start with, a generic applicable laws is really not going to do it in today's inspected world. So a reference to Sub M is better than nothing. But what we've provided here is sort of a more robust compliance clause, and I've actually sort of underlined where necessary some of the issues you just were addressing. So this is sort of call it a compliance and also sort of an audit clause, so to speak, where you're not only looking for assurances of compliance with specific federal regulations, but also production of initial documentation that you want to see to confirm compliance. And then I also add here to sort of cover the issue that we've talked about in our earlier case that has in place and is operating pursuant to an approved plan. And then obviously, like you just said, the inspection and record keeping requirements that ultimately lead in the last sentence to an obligation to produce, records of inspection so that you can continue to sort of maintain your oversight on the compliance.
Right. And of course, if anyone's concerned about confidentiality issues, you include a confidentiality clause so that information is not simply out on the streets, but that it's kept confidential between the parties or among the parties, unless, through litigation or government requirements, you have to turn it over.
Yeah. And so that's sort of a high level, look at sort of subchapter M compliance and some of the issues we've seen. And I think it's sort of a natural flow is, and so what do we do about COVID-19?
What do we do about COVID-19? Well, we can't stay home forever. And in fact, I was just talking to with one of our clients in the office earlier who's got several towboats, and on the river down here in New Orleans, probably like up in St. Louis and elsewhere, nothing stopped. Everything's still moving because, as Lance mentioned at the beginning, this industry is made up of essential workers, and it's a critical infrastructure industry, if you will. So nothing stopped on the river, nothing stopped on the bayous, nothing stopped on the lakes, and it keeps going. But what we have seen is a significant papering of the industry in terms of what needs to be followed, what needs to be documented, how do we deal with COVID-19. And really, if you think about it, while it's a pandemic and it is a disease that maybe is farther reaching than your typical flu in the sense that it's a little bit more called a little bit more dangerous, and it's affected people differently. At the same time, it's treated like any other medical condition and any other situation in which your employees are operating. You have to have the right system of checks and balances, just like you do on subchapter M, like you would have for COVID-19. And so you'll see the theme throughout. Are the people being taken care of in crew changes? Are the CDC and Coast Guard regulations being followed? Are the right notices put in place for reporting? Do you know when to quarantine someone? Having a program for not only COVID-19, but for disease control in your safety management system is important. And COVID has simply pushed that forward. And I think made people, Lance, would you agree, realize more now than ever that they're not just focused on the technicality of vessel operations, but actually you need to think bigger picture and what needs to be in your compliance program and responding to issues that are first aid related as well.
Right. So if you skip to the next slide, sort of there's a list, and this list is probably things that everybody has seen in the market as far as what's been suggested, best practices, Coast Guard guidance. But if you jump to the next slide, I have gotten a couple of questions, really just with respect, given the wide-ranging impacts, should we start thinking about COVID being covered under the TSMAs? And after all, some operations folks that are really on top of the details sub M will say, well, at TSMAs is to correct problems and facilitate continuous improvement. Why not? And I've been asked the question a couple of times, what is the Coast Guard's view? I personally, and if anybody on in the seminar has had indications, I'd like to hear. I have not gotten the sense that the Coast Guard sort of has a requirement for it.
No.
It's been sort of discussed. I would kind of similarly put it like cybersecurity.
Right.
But we all know from the MSIB, it's certainly been deemed a hazardous condition. So you're
Right.
sort of building the basis for the Coast Guard to claim that it should. I also know, and I actually may mention this to Mark when it happened, but for the folks that might be engaged in the liquid markets and participate in the SIRE inspection program, I've had an instance where a SIRE inspection sponsor requested an inspector to delve into that as part of the SIRE inspection, which, obviously is not necessarily regulatory in the truest sense, but that was obviously a major customer looking for that box to be checked.
And that makes sense because, when you're doing tankering, you may be interfaced with people at the terminal facility as well. And so the refineries and the terminal operators are going to want to know that your vessels are COVID free and that you've got a plan in place. But as, if not maybe more importantly, in addition to what the Coast Guard requires and what the customers are requiring is since you mentioned hazardous condition, Lance, let me pick up on that because if you don't have technically, arguably, theoretically, if you don't have a plan in place to deal with COVID and it's not properly implemented and followed on a regular basis like any other safety plan. Think of it as a safety plan. Okay. So, we get tripped up in the courtroom and in liability cases when you don't apply the plan consistently all the time. That's really crucial. And what does it create? An unseaworthy condition on the vessel, and an unseaworthy condition is a liability for the operator. And that's really, at the end of the day, what you wind up getting to is, do you have the right plan in place, whether it's under sub-M and in your TISMIS, and then dealing with health and safety for COVID-19, that is going to ensure that you have undertaken your due diligence and you are not negligent and you are following the statute and the law to maintain a seaworthy vessel.
Right. And on this slide, in response to some of the questioning I received from a client, I sort of with in my mind being concerned about some of the nasty consequences you talked before about just being in violation of a federal regulation, I kind of looked into what sort of the regulation itself said about, the TISMIS and whether it should or should not kind of include, COVID-19 response plan, a pandemic response plan, something of that nature. And I've just got on the slide some of the regulatory references that I think if you read as a whole, you could make a pretty compelling case that it should be. And starting with, the functional requirements of the TISMIS should include preparing for responding to emergency situations. And then the elements, almost verbatim must include policies that cover the approach to managing personnel, including health and safety of personnel.
It kind of fits in that bucket.
Right. And then if you read on, you got the health and safety requirements for a separate plan that would extend to sort of third parties and interacting with the vessel. So I think the basis is there. And I do think an enterprising plaintiff's attorney is going to look at that one day in the right case and say, yeah, this is worth making a run at.
Oh, no question. No question. They will shoehorn as much as they can into violation of a federal regulation, because if you violate a federal regulation, then you're presumed to be at fault and you're shifting the burden of proof. So it puts them in a much better situation than it does you.
Yeah, and if you jump to the next slide, so this is just sort of similar to our compliance checklist, just sort of another list of measures we've seen different clients implement to manage the risks, and ultimately I think to sort of build the basis to claim compliance if it ultimately becomes necessary. And I know a lot of folks that'll be participating have seen some iteration of a list like this. I do think one thing that I've had several clients that have been really good at is sort of 4 bullet points down is sort of in light of the modified crew change procedures that I think that everybody's implemented. There's been a real diligent effort to push out fleet-wide content that would sort of reinforce all of these things. And I've seen a couple really good sort of safety PowerPoints, on COVID, on, vessel interactions, visitor interactions, pushing out good content on the MSIB notifications, right. And then, just general operational safety in light of whatever the, federal, state, and local health officials are putting out. And it doesn't take much effort, but I think it builds a pretty good case that, we're on top of it and we're making sure we implement what it is that's out there.
No question. It's crucial. What do we have next?
So, yeah.
Next slide, force majeure. Well, we've seen a lot of force majeure situations, especially when COVID began. Everybody was trying to decide whether or not they could claim force majeure and eliminate some liabilities, suspend contracts, determining whether or not business and commerce would continue, and if not, whether or not force majeure clauses would be effective. We all have different force majeure clauses in our contracts. Some are specific and some are general. Some lawyers are a fan of a general clause because they like to think it just covers everything, and they can say that, well, it covers anything and everything in the world. Some clauses in force majeure, like indemnity clauses, have become very specific, and it's a full page of events that identify what conditions of force majeure. Remember, one thing to remember is while a force majeure event, I always like to say this, while a force majeure event is typically an act of God, an act of God is, while an act of God is a force majeure event, a force majeure is not always an act of God. So those two events are different. Okay, one can contain the other. So it's important to list what you see as the key elements of a force majeure event in your contract rather than having just a very broad clause. And also to cover government action. Government action in authority is very important because we are operating in a increased regulatory environment, and it doesn't go away, and it's becoming more difficult in operations. As we've seen during COVID, the government has taken a lot of activities or taken on a lot of actions that have curbed business activities. So having the right force majeure clause is very important. Y'all flip to the next slide, please. Now, what if it's not in the contract? Some people don't have force majeure clauses in your contract. That's not very common nowadays, but when you don't have a force majeure clause, you need to look to the jurisdiction in which you're located and determine what the actual law says, what the books say, the legal statutes say about whether or not a force majeure event takes place. And at the end of the day, it's really the same premise as what you set out in your force majeure clause, and that is performance is impossible. Performance cannot be undertaken given the circumstances that have arisen that are unknown, that are not caused by the fault or negligence of a party. Anything you want to add to that?
Yeah, no, I think that's I mean, that's really accurate. I think, and it is a question sometimes you lost on most people, is that the standard does vary depending on jurisdiction.
And of course, down here, we're in Louisiana, so it's a little bit different. We have the Napoleonic Code and civil law. But at the end of the day, if you don't have it in the contract, there will be a statute that covers it. So you have to find that. Can you flip to the next slide, please? Thank you. So the elements of a force majeure are really very simple. A force majeure event is something that adversely affects performance. It is beyond the reasonable control of the party declaring force majeure, and it could not have been avoided without reasonable steps. So if you think about it, just in layman's terms, it's all about due diligence, not being negligent at the end of the day. Something you could not avoid, regardless of what steps and what actions you take, the force majeure event, the event itself is going to take place, and it's going to prevent performance under the contract.
Yeah, I kind of stepped on that last point.
Yeah, that's all right. That's good. All right, we'll move on to the next slide. So impossibility of performance and commercial impracticability. Does that apply? And, we've seen a lot of situations in dealing with COVID-19 where companies have called and asked, does our force majeure clause apply? Because it says pandemics. And that's been quite interesting because, the U.S. government through the Department of Homeland Security issued the CISA guidance, which essentially says all these essential and critical workers have to go to work and they can keep working. Yet you may be in a situation where, because of the locale of the jurisdiction in which you're located, you're in a phase 1 or you're in a phase 2 and you haven't gotten to phase 3. And you may have restrictions placed upon your business, or it may just be that your people don't want to go to work, or they're concerned for their health, safety, and welfare, and so they want to follow the phase guidelines of the local jurisdiction. So it's possible, depending upon the facts of a particular situation, that the force majeure clause could apply, but it's possible that it cannot apply. So all that to say that the facts of a specific situation are going to control the application of a force majeure clause or a force majeure event.
Yeah, and I had one thing. And speaking of just sort of specific true maritime, issues that may arise under the general maritime law, and just for the audience, there are a couple reported decisions where, if you've specifically allocated a risk by contract, a federal court will say, well, no, that applies in lieu of the force majeure clause, because it's just general in a sense. And if it's more specific, the court will look to that other allocated risk clause. And I think the reported decision I saw had to do with a cargo, delay detention, and one party claiming the force majeure as a reason for the delay in performance, but the court finding, no, you've allocated that risk specifically. We're going to hold that clause sort of in preference to the general force majeure.
And that's a very good point, Lance, because a lot of the BIMCOs we see nowadays, right? For those of you who have dealt with BIMCOs, they specifically have a COVID-19 clause. Some people are putting them in their contract, some people are not, requiring that the vessel be COVID free, that the crew be COVID free, that if any directives are issued by the government related to COVID-19, it essentially has the same effect as a force majeure event. So those are issues to consider and to look for, and things that you may want to include depending upon your operations and your contract.
Right. So you could jump to the next slide.
The burden of proof. Of course, at the end of the day, the party that claims force majeure has to prove everything that we just talked about. They have to prove that that did in fact take place, that they could not avoid suspending performance, that they need the benefit of a force majeure clause. And then in establishing that burden of proof, if you wind up going to trial, do you want a judge or jury? Always depends on the jurisdiction in which you're in. If you have a very good story and it's very persuasive, maybe you're better off with a jury as opposed to a judge looking at the black letter law of what is a force majeure event, no matter what instructions the judge is going to give the jury. That's just a little 2 cents.
Yeah, I think that is helpful. And I think in my experience with some clients sort of recently, I think too, and maybe you could help speak to this, but as this drags on, you get a force majeure notice now saying, oh, well, I can't perform because of these reasons. I think you're really getting into that, have you exercised reasonable care, to avoid that interruption. And I think there's just an infinite number of things out there and arguments. I think if you're trying to avoid, the trigger of a force majeure clause, that you could argue as this continues to drag on. I think we saw
more and more difficult to keep that argument.
Right. Yeah. We saw a rash early, and I think everybody sort of responded. And now it's kind of, I saw one not too long ago on a ship construction contract, and it's, how many months are we out? 8, 9 months out. So I think they're going to continue to come, but I think it's the sort of, maybe, I guess, Lance Cedino's view is some of the power of that clause is going to be eroded.
Yeah, it's definitely deflated over time, no question. All right. The next slide, I think we actually kind of covered, but just to recap, with this industry, it does make it more difficult to declare force majeure in this situation of COVID-19 because the industry is deemed critical and essential infrastructure, and the workers are exempted from the lockdowns. So, depending upon the circumstances, again, you have to look at your workers, your employees, whether or not they can and will show up for work, and whether or not you have the capability to continue working and keeping vessels crewed and offices supported with staff. All right, next slide.
Yeah, no, so this is just sort of a tie up to what we said earlier. It's clear that as we've moved on to these, further technological resources to account for the disruption, it's raising, I think even more cybersecurity issues than we probably were even thinking about prior to the pandemic. And I think it's sort of consistent with what we've been saying all day, is it's a good time to sort of look internally at your loss control measures, but also to start looking at your customers and vendors and checking that box to see if they're compliant or they are implementing the correct systems. And I think this is a good one where I think Mark will tell you, we've all struggled with sort of drafting an appropriate cybersecurity provision.
Right.
But really what you need to be doing is sort of the diligence side. Your contract can say, and it may sound great, but it's, are you following through on some of these diligence items? And that's just been my view on, and some of the advice I've given to people.
Yeah, no, I agree, Lance. And the more I speak with the Coast Guard about the cyber issues, and so those of you who are involved in your maritime security committees probably know, but the Coast Guard is really focusing on cyber issues through the vessel security plans and taking a look at those and seeing if cyber is included. And I'll go back to a comment that Admiral Thomas, I think it was, made at some point. And he really captured it quite well. We talk about cybersecurity, but it's really cyber risk, and it's managing risk altogether. And that includes securing your operating systems. And now, since a lot of it is really more remote and on cell phones and laptops than before, given the fact that a lot of people are working from home, it's an increase in enhanced risk, and it's causing a lot of folks to go back to the table and reassess and reevaluate their cyber risks and look at where are the gaps in their programs to ensure that employees are complying with the checks and balances in the system and when getting online and when doing business and transacting business and having the security system in place, working from home as if they were working from the office. And so the workforce training is always a big issue because at the end of the day, you can have all the programs in the world in place, but if your people don't follow them, then you've got a breach and you've got a problem. And that could cause a domino effect, of course, within the company and with your customers. So having the right program in place and like Lance said, the system of checks and balances is crucial now more than ever.
Yeah, and I guess on the bullet on the cyber risk insurance, obviously it's always a good question to ask, but I will say from experience, I think when this all started to reach a fever pitch and folks were just sort of transitioning to working remotely, pushing out electronic questionnaires, involving all this electronics, I found brokers trying to catch up because either they had it and they wanted to make sure they understood what was going on because people just wanted to flip the switch and have no interruption in operations. Right. And it became, I think the insurance market, while it's a new product to begin with, I just think that there were a lot of brokers caught flat-footed trying to figure out, well, I got a client that they've got this, but now they're doing this, and assuming that it was covered. So I think if you have it, it's probably worth revisiting that to make sure whatever you have in place today is still going to make sure that you're not inadvertently walking into an exclusion.
No question about
so
that.
I think that's sort of another issue that's come out of this whole transition to a more virtual sort of environment.
Yeah, which also could result in exclusions to business interruption insurance as well, right?
Right. And like we said before, it's not a regulatory requirement, yet, but I think we can all agree it's probably headed that way. And I see we got a couple other minutes, and I guess I had a couple other things. So to jump back to COVID-19, just other issues that I think we probably both have seen, where we're probably right beyond renewal time for insurance. Right. I think we've both seen sort of an increased push by underwriters, even marine underwriters, to seek exclusions for COVID-19, sort of tying it into the communicable disease exclusion that you see sort of under a standard CGL. And that would be an exclusion for bodily injury or property damage, arising out of the actual, and I think some even say alleged transmission. So that, to your point earlier, makes the indemnities and what you have in your contracts all the more important. Right. And you need to double check and make sure that, they are broad enough and are sort of covering all the unique, local jurisdictional rules, Texas, the express negligence rule, general maritime law, express and conspicuous, all those things. I think it's worth to look back on in light of where I think some of the insurance is headed on COVID-19.
There's a lot more exclusions nowadays than there were when we started practicing.
Yeah, there really are. Yeah. And I guess same thing, we noted earlier, just sort of the, a couple things, increased cost. I think, implementing all these systems and sort of doing some of the diligence that we've talked about obviously comes with a cost. I have sort of encouraged clients, maybe as we're redoing contracts or even by amendment, if it's really, really a significant cost, is to look into change of law provisions that might allow for an escalation in rate, or just start putting that in there verbatim that there may be a basis to claim some percentage of a rate increase based on, my documented costs going forward. And I think, like you said before, BIMCO has sort of a form provision that they are sort of recommending to maybe the international market. And it's basically that if I've got a cost and I can sort of prove it to a certain degree of certainty, I should be entitled to a percentage, increase in rate. And then, I guess also when we noted before the I've also seen sort of an uptick given financial instability on contractual adequate assurance clauses, especially from like my owner clients who have maybe longer term, master transportation agreements, long-term time charters, and wanting some assurance from the customer that, if I really start to feel like your financial situation is in peril, I need to have some right, whether it's seek a change of payment terms, maybe go to prepay, look at other security that you're willing to offer, something to keep this moving, but to give me the assurance that, at the end of the day, I'm not going to be out significant money or holding cargo I can't do anything with, and things like that. So I've revisited several of those sort of, kind of issues and clauses with clients recently. And I think that's even more of an issue as it's kind of situations drug on.
Yeah, I was going to say it's really. The COVID has really accelerated a lot of those commercial realities and help people key in on them and to make those changes. As a lot of companies that I've seen are also doing the same thing and modifying contracts now,
right?
Modifying MSAs.
Yeah, and I will say too. I think we've referenced some BIMCO and there's Intertank Voy has some forms, and those forms I find those form provisions seem to be very extreme. And there never seemed to be a good fit for the inland industry. I think, the inland industry is a little bit closer of a community. I find there's a little bit more accommodating and willingness to work with each other. So if you just pull some of those BIMCO clauses and try to stick them in, you're really not going to get, very far, because they can all be very heavy-handed and don't really get the parties, I think, to a mutually acceptable result.
I'm usually rewriting the BIMCOs and taking a lot of the standard terms and conditions from bareboat time charters on the river and putting them in, because they're a lot more flexible and it doesn't shoehorn the parties into one side or another. So it does make a difference.
Yeah. So I guess, we covered quite a bit, and I know it's kind of at a high level. I don't think we've gotten any questions, but if anybody in the audience does have one, please feel free. And you can also, if it's not suitable for public dissemination, you could call one of us on the contact info on the slide here. But I think that sort of just wraps it up. I think we wanted to stay out of the weeds on some of these, suggestions on contractual provisions. I think we just wanted to give you kind of a high level view and reinforce the idea that, as I've told several clients, that resting on your laurels in an executed contract probably isn't going to be good enough now that we're in an inspected world. And I think Mark will tell you the same thing. Having some experience in sort of the Gulf of Mexico and OSV operators and offshore towing operators, you understand that world is different. And now it's kind of bringing the inland industry into that world.
It is.
And we've been dealing with some of these things offshore for years. And, it's still kind of an education. And I think today's idea that it goes beyond just an executed contract is a very important lesson.
Did you know right now there are I think the numbers are over 600 vessels that are not sub-in compliant yet in the district?
Really?
That they're chasing down.
Okay.
So
yeah,
to your point,
right. Yeah.
It's truly an inspected environment, and compliance issues and following not only your contracts but regulatory compliance is important, because that's where the industry decided to go, and it's now been imposed on the industry. So you got to adhere to it, unfortunately or fortunately.
Yeah, depending on how you look at it.
Yeah.
Yeah, and if need be, I can certainly sort of on some of these other lingering issues we covered quickly at the end with COVID-19. We didn't have slides, but we could certainly probably follow up with something on the exclusions, the increased cost, and the adequate assurance, if that would be helpful to people. But certainly all issues that sort of need to be considered and sort of fit too with the same idea of due diligence. Several clients have called just asking for a refresher on, what do I need to investigate on credit, things like that. So it's been pretty incredible how diverse the issues have been.
All right, no questions. Spence?
Hey Mark. Yeah, thanks, Mark and Lance. I thought that was great. Last chance for anyone who has questions. Take advantage of it if you can. Mark, do you want to talk about at all the potential webinars you have coming up with GNAPA?
Yeah, sure. I'll just take a couple minutes. So for those of you who know or don't know, I'm the moderator for the Greater New Orleans Barge Fleeting Association River and Marine Industry Seminar. And unfortunately, we did not have the seminar this year due to COVID-19, since it was scheduled for April. And the our executive committee has made the decision that we are going to start a panel or speaker series. And the first is on October 30th. And it'll be announced. We, of course, as always, love to team up with our partner, Spence of Waterways Journal, or Waterways Journal with Spence, and make some announcements. And we appreciate the opportunity. It's been a long year from that perspective, and not having the ability to really bring that education and outreach to the industry. So we'll be starting that. Please look for announcements to come out. But the first will be October 30th, and it'll be via Zoom, I believe.
Great. Yeah. I look forward to it. We'll get the word out on that the best we can, and I think everyone will look forward to that. So Lance and Mark, thank you very much. I want to remind everyone that this session's been recorded, and all of the sessions the last few days have been. So over the next week to 10 days, you'll see the sessions come back up on this site. You and your colleagues can come back on and view the sessions. Then it'll all be on demand. And of course, you can go and check out the exhibit hall all the way until 4 p.m. tonight. Please chat with our exhibitors and make some new connections. Again, Lance and Mark, thank you so much. Appreciate your time and expertise, and I look forward to talking with you again soon. Thank you.
Thank you.
Take care. Good luck with the program.
Thanks, Mark.